Hello and welcome everyone to this webinar on COVID-19 business interruption insurance claims. Tomorrow marks the 6-month period where the Supreme Court handed down their seminal decision in the case of FCA and Arch Insurance. So today we'll be discussing where policyholders now stand following that decision. We have the privilege today of being joined by two guest speakers, Neil Fawcett at 3PB Barristers and also Kevin Pearson from Quantuma. I should introduce myself also. My name's Nick Sutton. I'm a partner in the dispute resolution team at Fletcher. I have a background in insurance claims and specialise in insurance law for over 10 years now, but I practice general commercial litigation also. I'll just kick off by covering the background to this case. So obviously COVID-19 hit in early 2020 and not long after that we as a country in the UK went into lockdown in March, and by June 2020 there was clearly a considerable number of businesses nationally who were being hit very hard financially by this pandemic and the lockdown, and the Financial Conduct Authority appreciated that most insurers weren't responding to claims for business interruption around this. So a test case was brought under the Financial Markets Test Case Scheme, which was expedited through to the High Court in November 2020, and then was a number of findings of the High Court were appealed on both sides by the FCA and Hiscox Action Group, and also by various insurers. I should say that there were 8 insurers involved in the action, but there's actually 60 or so insurers who underwrite this sort of commercial risk. And the Supreme Court looked at 21 sample wordings, of which there are estimated to be about 700 variations of those wordings. So really just skimming the surface of potential cover out there. So the idea of the test case was obviously to bring some clarity and certainty to policyholders to see where they stand in relation to COVID-19 or disease-related business interruption, or whether business is impacted by a lockdown. And in particular, those businesses in the hospitality, retail, leisure, gyms, restaurants, entertainment, sports and events, pubs, clubs and bars, they were particularly impacted obviously by the lockdowns that we've had, and this decision is of critical importance to them. And so when the decision was handed down in January, insurers obviously had to take stock of the fact that this was, by and large, a victory for policyholders. There are a number of sort of discrete points that were qualified by the Supreme Court, but on the whole, the decision was a victory for policyholders. And at this point, the insurers had to begin paying out on claims. What we saw in the Supreme Court decision, I'm just going to touch on this to begin with before we get into the detail, was a number of covering clauses that were part of the sample wordings, which fell into 3 main categories. So we had disease, non-damage denial of access, and hybrid, which is sort of a combination of the two. And in most of those covering clauses, it was decided that there would be cover. And we don't have time today to go into the sort of the minutiae and detail of each of those sample wordings, because there were sample wordings for each of those for the 8 insurers party to the case. But by and large, most disease clauses where they refer to any human contagious disease or any human notifiable disease were held to cover COVID-19. We'll come on to shortly some types of wording that perhaps don't cover COVID-19, and I'll come on to that in a moment. Non-damage denial of access, those are clauses that relate to actions of competent authorities or a local authority, which again could be a local government or the national government who would order a business to close. So not necessarily because of disease, but an order to close. And obviously the originating source of that closure is disease, but it's not included in that particular type of wording. And then the third is a combination of the two, which combines disease and closure as a condition of cover. It wasn't, the decision itself wasn't a sort of blank check for policyholders to say to insurers, right, pay up. There are trigger and qualifying evidential burdens under these types of clauses. So, for example, in the disease policy wordings, policyholders would still have to prove that there's been COVID-19 within the relevant policy area. So whether that's within 25 miles, within 1 mile, we'll come on to on the premises clauses in a moment, but within the relevant policy area, a policyholder still has the burden of proof to prove that COVID-19 was present. But it all depends on the wording, and I say we don't have time today to go into the fine detail of each different type of wording. We've got a couple of exact sample wordings to go through. Before we get on to that, I just wanted to cover off some of the FCA statistics. Originally, when I was preparing for this webinar, the most recent ones were on the 14th of June, so exactly a month ago today. And interestingly, these figures, which you'll see here, the 750 million, which has been paid out by insurers to date, the 37,000 claims that have been accepted by insurers, and the 16,000 or so that have been settled and paid on a full and final basis. Those figures haven't changed very much at all since June. So in a month, there's only been another 30 claims that have been settled on a full and final basis. In terms of where we are now procedurally, 6 months on from the Supreme Court decision, my view that there's still a considerable number of policyholders who've either not made claims or whose claims are yet to be accepted. I've had many inquiries where individual policyholders have been told they don't have a claim, or their insurance brokers told them they don't have a claim, and we've looked at the policy and actually there's potentially cover there. So my view is that this is it's just the beginning of the whole process. 6 months in the scale of litigation, which can often go on for years, is just the beginning, really. So in terms of the numbers, as I've said there, there's 370,000 policyholders who are potentially impacted by this decision, 16,000 claims paid in full and final. What of the remaining 330,000 policyholders? What is the position with their claims? Sort of any human notifiable, any human infectious disease. But Rockcliffe was different, wasn't it, in terms of the precise wording considered? It was a specified list or a closed list. That was the differentiator, I think.
Yeah, that's right. So, Rockcliffe was essentially a case where they had the list of diseases. So you can see that there is, for example, acute encephalitis, leprosy, plague. Those are lists of diseases where what they actually do is they take the list from statute. There is a sort of framework called the health protection notification regulations, which actually provides that you've got to notify certain types of disease. Essentially, if a GP gets a case in front of somebody who's got, plague or rabies even, or Ebola or something like that, you've actually got to notify it to a local authority. They can take relevant sort of action to protect the public, and those lists of diseases actually form what are supposed to be notified by medical professionals. What happened in Rockcliffe is they actually took that list of diseases and put it into the policy. So my argument was essentially, well, what's the difference? Either in some cases you use the term notifiable disease, referring to the list, or in other cases, like Rockcliffe, you just import the list into the policy. What's the difference? That was essentially us saying that there was a sort of analogy that you could draw between the FCA test case and the case in Rockcliffe. The court didn't go with that, unfortunately. What the court said was that actually Rockcliffe was slightly different. It's a static list, as they said. So it's not a list where you can actually look at the wording in the statute in Schedule 1 of the Health Protection Notification Regulations and say, look, that was a schedule that can be added to or removed from. The court said, well, when you've actually got the list in the policy, it's got to be literally within the four corners of that list. So unfortunately, we couldn't get COVID-19 into that. We also made the point about that COVID-19 also included plague, and Unfortunately, as well, the court didn't go with that either. It was based on dictionary definitions and whether or not people in modern times refer to plague as simply the disease caused by Yersinia pestis, or alternatively, as we were saying, is plague actually a far more widely defined disease per the dictionary definitions, and they didn't go with it, unfortunately.
I think that is a bit of a blow to policyholders, but still there's other areas as well. I'm just moving on slightly, Neil, to the second sort of sample wording we've been having a look, and this has come up quite a lot on my cases. It's on the premises clauses, which seems to be causing quite a bit of a stir amongst insurers, because they're saying, well, this type of wording wasn't considered as part of the test case, therefore it doesn't apply, or the FCA, the Supreme Court decision doesn't affect your case, as it's often worded in the response letters. So, I mean, what's your view around this? Because, I mean, I've obviously arguing that, in terms of the specified radius or the relevant policy area, I mean, on the premises is arguably more proximate than COVID occurring 25 miles away.
It's quite a difficult type of question, in that with insurers at the moment, they are certainly saying, look, we require it to be at the depending on obviously the wording, we require COVID to actually be manifested on the premises. There are a lot of questions about how you actually go about this. The first is, well, what does manifestation mean? It's been defined certainly in FCA 1 as being not necessarily a COVID test, because of course COVID was actually very difficult to test for, especially at the time that lockdown happened. So you can actually prove manifestation by, for example, evidence of somebody having a cough or other symptoms. I mean, quite literally, I did a letter of claim only yesterday for a company where we actually put a table of all of the staff and children at this particular business. It's a childcare business, and literally all of the symptoms that they were suffering, such as loss of taste, loss of sense of smell, cough, fever, that kind of thing.
Yeah.
So firstly, I mean, manifestation's actually quite a wide term. So you don't necessarily need to actually show a COVID test. The next point is, well, actually, where's it manifested? And some policies will say it needs to be manifested in a 25-mile radius. Some policies say it needs to be manifested actually at the premises, and that's the one where it causes the most difficulty. Because obviously within 25 miles isn't so bad, because you can say, look, there's a care home down the road, or we're next to a hospital, or whatever it might be. But actually, where you've got policy wordings which say that you've got to manifest on the premises, there is actually guidance from the FCA about how you go about proving that, and it's actually on a very similar basis. But it's sort of important to understand what the reason is for the sort of the proof within 25 miles. So what the Supreme Court said was that it's sufficient to prove that the interruption was a result of government action taken in response to cases of diseases which included at least one within the geographical area. Now, the reason for that is that the court basically had to work out what causation meant, because ordinarily causation used to mean, before this case, something based on the but-for test, which is essentially that but for one thing happening, another thing would not have happened. The problem is that you actually find it very difficult to apply that to COVID. I mean, what exactly is it that caused the government interference with your business? It surely can't have been the whole pandemic, because according to the policy wording, it says an occurrence of disease. So based on the fact that we're actually interpreting the policy wording rather than just asking the question. So it can't be everything, and it can't be literally that one particular case within your radius or at your premises. So what is it? And the kind of, I mean, I think it's a bit of a fudge, but the rationale at 212 is, the formula is, you've got to prove at least one case within your geographical area, and then that case, along with all of the other instances of COVID across the country, caused the interference. So the point is that actually, if instead of proving your one case of COVID within 25 miles, you've got to prove your one case of COVID at the premises, you can actually go about doing that by saying, well, look, we're a premises which is of, a reasonable size. We've got a geographical area because we are a golf course or a shopping centre, or we might even be a large sort of a pub or large shop or whatever it is. During the week, we on average have a footfall of X many thousand or whatever it is, and we actually are based 5 minutes from a care home. We also are in a local authority area that has a very high COVID infection rate. So what you say is, well, look, why can't I get an actuary to do a report to take all of those variables and say, look, in any month or any week, the likelihood of there being a COVID case at that premises was, hopefully 51%.
Yeah. But this is the point, isn't it? It's on the balance of probabilities. You don't have to prove definitively 100%. It's what on the balance of probabilities was COVID likely to have been on the premises. I think if that's the sort of realm of evidence you're going into, it's an interesting point. But I think was the expression that's been used approximate and effective cause. So all cases of COVID, whilst not sufficient or necessary to cause the national lockdown, were all effective and proximate causes of the regulations and restrictions that have come into place. So whether it's within 25 miles or on the premises, they're effectively, that one case of COVID on the premises, if it's proven on the balance of probabilities, is still a proximate and effective cause of the national lockdown. So that's how the argument goes, as I understand it. But it's an interesting one, which I say is being pushed back on quite a bit. And just some other areas I want to touch upon as well, Neil, was around sort of notifiable disease with lists, because I've seen this come up a couple of times where you say, it's a notifiable disease and an outbreak of which has to be notified to the competent authority, but then there's the list. Do you think that's pretty much a dead end now in terms of if there is a static list, that even if it says notifiable or an outbreak of which is to be notified, that we're still going to not get past the line on it, or do you think there's still good prospects there?
It's kind of debatable. I mean, the Rockcliffe case certainly I think is a difficulty for those types of cases where you've got a static list. There are a couple of things to consider though, because actually there are two types of case that I'm dealing with at the moment where they may actually have quite good arguments, even though there is a sort of static list. The first type of those cases is where they actually have SARS on the list.
Yeah.
The Rockcliffe case, of course, was one where we argued that COVID could be plague, or COVID could be encephalitis, or other diseases. And actually, mind you, if you look at a lot of these diseases and you look at the dictionary definitions, they are particularly wide. I mean, if you look at, say, encephalitis, it says, swelling of the brain, and it can be caused by pretty much, anything, bacteria, viruses, genetic conditions, pretty much anything. Yeah. Some of these lists actually have just literally the acronym SARS on the list, and that's actually quite an interesting sort of definition. But the question is, for the court, did the policy mean that SARS was anything that essentially falls within the definition SARS, or does it mean that actually SARS was the 2003 outbreak in Asia, and it doesn't include COVID? And there are quite a few arguments which actually, certainly my view on those cases is that actually they've got prospects, because if you were to, for example, define SARS as only meaning the 2003 outbreak in Asia, the problem is that happened it happened in a particular way, and it's not going to happen again in that way. So the question
Why
is,
insure it? Why insure something that's never going to happen again? And that's
why ensure
why would a
something that's never going to
policyholder
happen
take
again?
out insurance for a disease that's never going to occur again? I mean, that's just doesn't make sense.
Well, exactly, and it's almost sort of definitional as well, because if you actually try to define what SARS means, if you're going to adopt the position that the policy refers to the 2003 outbreak in Asia, the difficulty is going to be that it can't, by definition, actually take place in Asia in the same way again. So they must have, by definition, been referring to something slightly wider. So the question for us is, well, actually, what is that slightly wider thing? So we've been looking at, for example, getting expert evidence from, somebody who's an epidemiologist or virologist who can tell us, well, what does SARS mean? What does it include? Are all the various mutations of COVID-19 also SARS? Is COVID-19 SARS, etc.? So I think those ones have got, prospects based on expert evidence. There's also this other type of wording of those same lists. So you do actually have these static lists where they're sort of almost sandwiched between slightly odd wording. Because in the Rockcliffe case, actually, what they had as the list was simply a list that followed the words specified disease means, and then they copied the list out, and the court said that means that you've just got to look at the four corners of the list. The policy wordings that I've seen, quite a few of them, actually have this sort of wording either side of the list. So they for example, they say things like, we will insure any notifiable disease under Schedule 1 of the Health Protection Regulations, which are, and then they list a number of diseases. So the question is, well, what does that mean? They kind of do both. They sort of refer to notifiable disease, and then they list what the diseases are. So the question is, are they sort of taking a subset from the external list, or are they sort of saying, well, we're ensuring what's in the external list, and by the way, for your information, this is what the list says?
I suspect there's a bit of a cut and paste job going on in terms of, notifiable, referring to the regulations, and then including lists as they were at that point in time. But I think you've touched an important point there, which is, are the courts taking a literal approach to this or a more purposive approach? Once you've established there is cover, how much is the claim worth? And that's kind of the big question for policyholders. They want to know how much they're going to get at the end of the day.
It's always that chicken and egg, because we get people coming to us and asking about quantification when they haven't yet fully worked out the policy side of things, and therefore whether there is, an entitlement to make a claim. So in those situations, I always say to the people, go and sort out the coverage side before you get onto quantum. But in terms of quantum, the policy is, again, the best place to start, because the wording differs slightly between most of the policies we're seeing, but in the majority of cases, there is guidance there as to how the quantification process should be approached. So the general principle, obviously, is that, one is putting together a claim to look at effectively the profits that have been lost as a result of the event, and even what the event is has an impact, because some policies can refer to, for example, not being able to access offices, and then you have to think about whether it's the access to the office that stopped profit coming in, or it's the wider COVID impact. But putting those things aside, most policies will actually say, and or in practice, that the best thing is to look at revenue as a starting point in the period impacted compared to the same period in the prior year. And we'll come on to the kind of complicating factors, but for most businesses, in particular at the smaller end of the scale, looking at what they did in the same months of the previous year is A, probably what it may say in the policy, but B, the best way of working out what their revenue would have been. Now, once you've looked at the revenue that's been lost, you then need to take account of the costs. Now, gross profit is normally quite easy to work out as a percentage, because effectively it's the cost of sales that the business would have incurred in making those sales, and those are often, if you've got a restaurant, it's things like food, etc., that you've saved those costs.
Yeah.
Where things get slightly more complicated is where you're talking about the more general cost of the business, because often, what you'll be looking at is the extent to which the business has costs which are variable, and therefore that they may have saved, whereas fixed costs will be incurred regardless. So it's often necessary to split out those costs and try and work out which ones effectively have been saved and which ones have still been incurred. Where with BI claims on COVID, it's much more complicated than normal BI claims, is because of the FCA and other guidance around grants, etc. Now, this whole area is still a pretty grey area, and I don't think any of us on the call would want to give a definitive answer. But the understanding I have is that based on the FCA guidance, it's widely accepted that grants that businesses have received as a result of COVID should just be ignored on the whole, and consequently things can, the businesses don't need to deduct them from their claim. However, furlough monies remain a much greyer area. And I'm aware of, some cases where people have successfully made the case that, that should be ignored, and others where insurers are kicking back hard and saying, well, you've made that saving, so therefore that should be deducted. So I think, obviously we're covering a lot here, but the last thing I'd say is for companies looking to put together claims, make sure you've got and have kept clear accounting records, because ultimately, if you don't have a clear record of both your historic trading and your trading during the period where COVID's impacted, it's going to be very hard to put forward a meaningful claim. The other thing I'd say from experience is it's always better to put forward a credible and supported claim rather than aiming for something overly optimistic, ignoring some of the realities on the business, on costs, etc. Because in my experience, it's a lot easier to negotiate a settlement if you're starting from a sensible position, whereas if you're starting from a very high position, there's often an element of skepticism going forward.
Just in terms of the assessment and calculation, I thought we just mentioned indemnity limits in policies, because this comes up quite a bit, where an insured has an insured sum, and it could be for however much the sort of total annual turnover of a business, and then you'll have an inner indemnity limit or a sub limit which kind of restricts a particular event or occurrence of loss. Are you seeing that causing any problems on cases that you've had a look at, or you looked at purely from the accounting perspective, and what's been your experience of those?
Yeah, I mean, generally we're looking at the numbers, if you like, in absolute terms, but this is something I'm hearing about quite a bit from people on both sides of the fence, that it's being deployed as an argument to reduce payments, and it's obviously conceptually quite easy to understand. I mean, often it's something that people just haven't thought about in their policy.
Yeah. I think another interesting point with indemnity limits is one, perhaps this is one for you, Neil, is where it's either unclear that there's an aggregate or it's per occurrence and loss. And of course, we've had 3 lockdowns covering different periods, and I've seen some insurers saying, well, you're only entitled to the indemnity limit for, say, the disease cover for the entire year or the entire indemnity period. Others are treating it as, well, each lockdown is a discrete event, and therefore you can only be indemnified for that. And that's particularly problematic for policyholders whose policies expire between the first and second lockdown, because then, of course, they're not necessarily going to be covered for lockdown 2 and 3. So that significantly reduces the indemnity. But I presume you've seen that on a number of cases as well.
Yeah. There are so many arguments which arise based on different policy wordings about how you actually treat the losses, especially where you've got businesses with multiple premises. And this you see actually a lot with pub chains, hotels, things like that, where there are sort of a number of insured locations on the policy schedule. The way in which you actually treat that loss is normally dealt with in the policy wording itself under the disease clause, and some policy wordings will say things like, we limit our total claim for any one loss to, and then they'll give a sort of inner indemnity limit. What you often find, and the reason why it's relevant in these cases, is because actually on the policy schedule, you'll think that you're insured up to, whatever it is, 500,000, a million or more, your total turnover. But when you actually look at the disease clause itself, it turns out that you're limited in a lot of cases to £25,000 or £100,000 or whatever it might be, and so of course then it becomes very relevant as to whether you're saying that's £100,000 for each lockdown or £100,000 for each lockdown for each premises, or whether it's £100,000 full stop under this policy.
Which makes a huge difference.
Which makes a huge difference.
Claim if you've got 13 premises, well, quite.